Good morning, good afternoon, and good evening. My name is Martin Reggie, and I am an Associate Program Officer within the United Nations Office on Drugs and Crime, UNODC, and the Terrorism Prevention Branch's CPRN Terrorism Prevention Program. Firstly, I would like to thank participants for attending today's webinar. I would like to convey UNODC's gratitude to the European Union for enabling this important activity and for its crucial contribution to the promotion of the International Convention for the Suppression of Acts of Nuclear Terrorism, ICSANT, through the EU-funded project on Union support for the universalization and effective implementation of ICSANT. Today's webinar is the first of 10 planned webinars on various key aspects of ICSANT. ICSANT is an essential tool for preventing nuclear and radiological terrorism and improving nuclear security worldwide. It contains essential provisions dealing with international cooperation in criminal matters related to the offenses it establishes. ICSANT can benefit all states parties by facilitating international cooperation, including the exchange of information on radiological and nuclear terrorism threats and prosecution or extradition. Today's webinar focuses on a prosecutorial perspective on ICSANT. UNODC, through its CBRN programming funded by Canada and the European Union, assists member states by building the capacity of criminal justice officials, including prosecutors, related to ICSANT. As you'll see today, the prosecutor plays a key role when it comes to criminal conduct involving nuclear or other radioactive material. ICSANT and the materials it covers present certain particularities in relation to criminal proceedings, inter alia, with regard to evidence gathering, preservation, and admissibility, and international cooperation. Soon, you will hear from Mr. Simon Minks, the National Coordinating Advocate General, Counterterrorism, Violent and International Crimes, as a Senior Prosecutor in Appeal of the Netherlands. But before that, I'd like to give you a brief primer on ICSANT to help build the baseline for today's presentations. So as mentioned, I work within UNODC's CBRN Terrorism Prevention Program, where we work to promote ICSANT. I'm very happy to welcome you all today. For diving a little bit deeper into the substance of the convention itself, I would just like to highlight some recent remarks from the Executive Director of UNODC, Ms. Ghada Wali. Ms. Wali stated that the risk of nuclear and other radioactive material falling into the wrong hands and being used for terrorist or other criminal purposes is one of the greatest challenges of our time. And as such, all states need to establish robust and sustainable legal frameworks to counter this threat. At UNODC, for 2 decades, we've been at the forefront of efforts to promote universalization and effective implementation of the counterterrorism international legal instruments, including ICSANT. So you can see it's a two-folded approach. It's not only universalization of the instruments itself, including ICSANT, but also effective implementation by adhering to all of the obligations that are included in those instruments. Just a short historical background on ICSANT. Negotiations were called to address gaps in the international legal framework for preventing and responding to acts of nuclear terrorism. ICSANT was drafted by an ad hoc committee established by the UN General Assembly in 1996. The convention was adopted by the General Assembly in April 2005 and opened for signature in September 2005. It entered into force on 7th of July 2007, recently celebrated the 15th anniversary of entry into force back in 2022. And the depository of the convention is the UN Secretary General. We've had a recent run of new parties, with Palau being the most recent in February as the 124th state party. And we're very happy to join and welcome new parties to the convention. ICSANT is one of 19 international legal instruments against terrorism, 7 of which deal to varying degrees with CBRN terrorism. It follows a similar structure to other CT treaties, specifically by criminalizing certain acts and conduct, including some that you'll hear about later. The instruments also include certain instances of mandatory and optional jurisdiction, as well as the principle of extradite or prosecute, or addendere et judicare, which combined with the criminalization provisions ensures that there are no lacunas or gaps where criminal actors might seek to flee to or carry out certain acts. And lastly, there are mechanisms for international cooperation that you'll hear a little bit more about in the forthcoming slides. Article 2 deals with the criminalization provisions under ICSANT. Specifically, ICSANT establishes offenses including radioactive material, radioactive devices, or nuclear facilities where they have been committed unlawfully, that is in the absence of legitimate justification, and intentionally, that is deliberately. Some of this you'll hear from Simon as well, so I won't go into too much detail, but the offenses themselves range from illicit possession or use of nuclear or other radioactive material or radioactive devices to damage to nuclear facilities, and they also include some ancillary offenses that are listed there. The list of offenses to be criminalized pursuant to the convention can be found in its Article 2. It's important to know that in order for an offense to fall under ICSANT, it needs to be committed with a specific intent. Those intent include the intent to cause death, serious bodily injury, or substantial damage to the property or the environment. And also there is the intent to compel a natural or legal person, an international organization or state to do or refrain from doing an act, the so-called terrorist intent. Jurisdiction is covered in the convention as well. There are certain instances of mandatory jurisdiction where a state needs to include those within its implementing legislation, and as well there are instances of optional jurisdiction where a state can choose to cover those as well. Article 9 lays out the instances of a mandatory jurisdiction. I've talked a little bit briefly about the principle of extradite or prosecute. This obligation, together with the jurisdiction provisions, aims to allow as many states as possible to prosecute the offense and prevent legal loopholes to be exploited and deny the creation of safe havens. All states must establish jurisdiction under Article 9, as I've said, and really this coupled with the criminalization provisions is key to ensuring that ICSANT has its full effect. We won't talk too much today about international cooperation because there are some upcoming webinars that will deal more specifically with those, but I just wanted to highlight a few that would be relevant to prosecutors. Specifically, ICSANT contains provisions to facilitate and enhance international cooperation in criminal matters among states parties, including extradition and mutual legal assistance, of which we will have a dedicated webinar in June. This also includes, for example, the exchange of evidence, the exchange among state parties and with competent international organizations of relevant information to prevent, detect, suppress, and investigate offenses under the convention through competent authorities and liaison points under its Article 7.4. States parties are required to cooperate by taking all practicable measures to prevent offenses under the conventions, including by enacting appropriate legislation giving effect to those criminalization provisions. The benefits of adherence you'll see listed here. Specifically, I'll highlight one, that is the establishment of common definitions and minimum standards in the field of nuclear security. So working from a common set of definitions can really be a benefit to states parties when they are exercising these international cooperation mechanisms to ensure that they're really starting from a baseline and common vocabulary. I'll just highlight very briefly the UNODC ICSANT website, which I encourage you all to visit. It includes all of the tools that we've developed under our programming. It's available in all 6 UN official languages and is regularly updated. A few tools include Module 6 on CT legal training curriculum, available in all 6 UN official languages. A manual of fictional cases on ICSANT, with a focus on the criminalization provisions that you'll hear about today. That's available in all 6 official languages of the United Nations, as well as Portuguese. And lastly, a forthcoming tool developed with the UN International Criminal Research Institute, UNODC, and other partners, which is forthcoming. So I'll thank you for allowing me to give you a brief primer. And with that, I'll welcome today's speaker, a longtime friend of the Terrorism Prevention Branch of UNODC. Mr. Simon Minks has specialized in counterterrorism and war crimes since 2005. He served for many years as liaison magistrate with the International Criminal Court, the ICC, the Mechanism for International Criminal Tribunals, the MICT, and embassies. Prior to his current position as a senior public prosecutor, Mr. Minks was a practicing lawyer for 10 years. Throughout his career, Mr. Minks has prosecuted highly sensitive cases, including many involving national and international terrorists. Mr. Minks gives trainings and presentations for judges, prosecutors, lawyers, and policemen worldwide, and guest lectures at national and international universities. Just in terms of the process of today's webinar as well, we will be having a brief Q&A session following the presentation. If you have any questions, please email them to unodc-icsant@un.org, and we will attempt to answer them during the allocated time. So with that, Simon, I'll share your presentation, and the floor is yours.
Thank you very much, Martin. Welcome, everyone. Thank you for watching this webinar. Thank you, UNODC, Maria Sobrado and your team, and all the other partners for having me in this important series. And thank you, Martin, for the kind introduction. The people who know me a little bit know that I'm used to talk for many hours about topics related to counterterrorism. So today I have 45 minutes, and you can imagine that would be a real challenge for me, but I will do my very best to finish it in these given limit. And last but not least, I must admit also that I'm a little bit clumsy, so I asked UNODC to help me to move the slides from time to time, so I will ask them to go to the next slide. So I prepared for you a PowerPoint presentation with some, I hope, interesting slides, more specific for prosecutors, but hopefully also interesting for policymakers, representatives from other countries who are experiencing possibility of a nuclear or radiological incident or crime. Because for many years, there is a great concern that terrorists would obtain nuclear or radiological weapons and detonate them in a large city. Experts and senior officials frequently state that this scenario is a matter of when, not if. So this concern became even more urgent after it was learned that Al-Qaeda has sought access to nuclear material and technical knowledge associated with building a nuclear weapon. And it remains a concern with ISIS or IS and other violent extremist organizations. Like you can see on this slide, President Obama in 2016 warned that the danger of a terrorist group obtaining and using a nuclear weapon is one of the greatest threats to global security. And that's still the situation nowadays. By the way, if you see a blue line on the slide, that is the source of the bullet points. So if you want to read something more about that, you can find it in blue. So maybe we can go on to the next slide. The next slide shows you that we are not talking only about terrorist organizations, but sometimes also a combination of organized crime organization in relation to terrorist organization, to state terrorism, like this one. As you can see, recently these persons were arrested, and the charges are at the moment conspiring with a network of associates to traffic nuclear materials. It was an undercover operation, and as you will see later during this presentation, that is one of the techniques you have to use in this very complicated and sensitive crimes. The person of interest in this particular case thought that he was selling nuclear materials to a foreign general for the use of nuclear weapons for their program, and aimed to purchase military-grade weapons on behalf of an ethnic insurgent group, according to the current indictments. So it shows that it is not only fiction, it's not only in Hollywood, it is a real serious problem, as we can see right now. Okay, let's move on to the next slide, please. And sometimes, sometimes it's not a crime, but there is something missing. That's one of the challenges prosecutors face, whether to qualify the facts as a crime or just an incident. But nevertheless, it could cause a lot of trouble, as you can see here, what happened in Libya in 2023, where a lot of natural uranium reported missing. And you can imagine that there are a lot of potential organizations and maybe persons interested in getting this material. Okay, let's go to the next slide. This is another example. This is about cobalt-60, the radioactive source. And also there you can see, if you are talking about ICSANT topics, it doesn't have to be big. It could also be quite small. Just in this example, as you can see, it's just a few millimeters in a 50-kilogram container. So you have to be aware about this, this content. It could be really small. Okay, let's move on to the next one. So what I try to explain is that you could face, as a prosecutor or an investigator, different situations. Is it an incident? Is it a crime? And one of the first questions you have to ask yourself as a prosecutor, but also as an investigator working together with the prosecutor, do we have the legislation in place? Do we have the legislation? And who is calling who in terms of, one of the nightmare scenarios in my head as a CT prosecutor is this phone call that will come always on Friday afternoon, late afternoon, or on Saturday when no one else is in the office, and that the person on the phone is saying, okay, there has been some kind of explosion, and it might be a dirty bomb. Who am I calling to call then? I mean, I'm a prosecutor, maybe I'm still in the office, maybe I'm working from home from that. You have to be aware of what partners are involved in solving this kind of incidents or crimes. And who is responsible for the crime scene management? That's another challenge, because you can imagine if you cut such a call, there will be an ambulance, the fire brigade, but as a prosecutor, I am interested in collecting evidence. while the fire brigade is interested in, in other things. But who is in charge? Who will be in charge of what I consider the crime scene? And who is responsible for the personnel to stand to the crime scene? I mean, if I had some knowledge about the possible content of this explosion, if I think there must be radiation at stake, do I send the police as prosecutor without any protection to the crime scene, or do I have to wait for specialized forces, specialized departments from the military or the police to go there? There is also responsible for the prosecutor in a civil law system where I'm working in. So there are a lot of questions to be addressed, and this is one of them. Okay, let's move on to the next slide, please. We are talking about ICSANT. That means that there must be an international incident or an international crime. But who are the suspects? Is it an organized crime group or an organized crime group with a terrorist intent? Is it a citizen? And another thing you have to realize when you are a prosecutor, but also when you are a policymaker, we only have a limited number of prosecutors and investigators. So how many prosecutors do you have for specialized cases like this? And how many legal assistants do you have? Because you have to work together. And the same goes for the investigators, for the police. You are working together as a team. And in my jurisdiction, for instance, I have to defend from time to time how many prosecutors or how many policemen or women I really need to conduct this investigation. And if I'm not convincing enough, and in the meantime, there are other crimes committed in the Netherlands, my other colleagues are saying, all right, you had your time, and now it's our time, and I will get the police. So this is one of the things you have to keep in mind, especially when you consider the possibility that such a case, if it is a criminal case, will definitely go in appeal. So my advice would be, if you are considering a prosecution situation, make an agreement from the very beginning with the police, with your leadership, that you need police for a longer time than you are used to in this kind of criminal affairs. And then another very challenging question to address is, what kind of charges do you only use simple, ordinary crimes? Do you keep it simple? Or do you go to the CBRN charges, including looking for accomplices? And if you are thinking about that, you cannot do that without thinking about the situation of the pretrial detention, the political issues, who are going hand in hand together with incidents where radioactive material is at stake, where CBRN material is at stake. And another also important question you have to address, and I come back later during this presentation, is, do you really understand the content where you are dealing with? Do you understand the expert witness? Do you speak the same language? Did you ever hear about accents? Okay, let's move on. So the work we are trying to do is to prevent that a dirty bomb will be used. And for your understanding, a dirty bomb in theory is a conventional weapon that has been augmented with radiological substance. So I am not an expert on the content, I'm just a simple prosecutor. But from what I understand, that there is just a simple mechanism, a conventional explosive mechanism, including radiological substance, that could impose fear. And that's exactly what terrorists want. So even if the consequences are not that bad in terms of that people get wounded or whatsoever, but there will be fear. And that's exactly what terrorists want. Fear, imposing fear, trying to coerce a government to do something or to withhold something. Okay, let's move on to the next slide. And as I said, it's not only fiction. I started this presentation by showing you a slide about the mafia. But it's not only the mafia who is looking for this material, it's also ISIS, another terrorist organization. And you would be surprised who would be involved. These organizations need specialists. And as this slide shows you, in this particular slide, we speak about a senior researcher from Belgium, working in a Belgian nuclear center that produces a significant portion of the world supply of radioisotopes. So that is a very interesting person to get on board of the terrorist group. They need persons like that to commit such a crime. Let's move on. And let me tell you something about how we in the Netherlands are organized when it comes to this kind of counterterrorism issues. Now we have two national public prosecutor offices. And the first one on top is the one who is dealing with organized crime. It has also a special international war crimes unit, because make no mistake, using this material by terrorists or by states could also be qualified as a war crime or as a crime against humanity. So these people, these colleagues who are only dealing with international crimes, are more specific also interested in this material. We have a special prosecutor dealing with financing terrorism, and every district prosecution office has at least one colleague who is specialized in counterterrorism. And then in appeal, you see the National Coordinating Counterterrorism Advocate General, who is the prosecutor in appeal, also coordinating on a nationwide basis these cases. Okay, let's move on. Now, I am fully aware, and I hope you are also fully aware, that if you are talking about ICSANT, you have an international situation. And that could also mean that two different legal systems are at stake. And most of you are fully aware about the difference between the common law system and the civil law system countries. Also said the adversarial versus the inquisitorial legal systems. And it is important to understand the differences, because if you have to work together, and we will come back to that later in another webinar when we are talking about the international cooperation and mutual legal assistance, but you must understand, for instance, that in the common law countries, the prosecution and the defense compete against each other, and the judge serves as a referee to ensure the fairness to the accused, and that the legal rules criminal procedure will be followed. And according to that system, that assumes that the best way to get to the truth of a matter, so including the ICSANT situations, is through a competitive process to determine the facts and application of the law currently. Now, the inquisitorial system is associated with the civil law. That's working otherwise. It is characterized by an extensive pre-trial investigation. This is happening in my country, in the Netherlands. And the interrogations with the objective to avoid bringing an innocent person to trial. And it can be described as an official inquiry to ascertain the truth, whereas the adversarial system uses a more competitive process between the prosecution and the defense to determine the facts. So there are some differences in different roles, also from the perspective of the judge, but also from the perspective of the prosecutor. And I come back to that later. To the next slide, please. Now, one of the most important and common rules of the prosecutor is to oversee the police investigations, to make sure due process of law, and in order to meet the rule of law standards and strengthen public confidence in the authority of the police to conduct investigations in a manner that balances the rights of the individuals. The investigative work of law enforcement must be monitored. So this supervisory role is in both systems one of the most important roles to play. Another important function of the prosecutor in this regard is to give recommendations to the police investigator. And the extent of such authority varies from country to country, from non-binding advice to complete prosecutorial control over the police investigation. And in common law countries with a common law tradition, such as in Kenya or in Tanzania or the United Kingdom, the prosecutors play no role in the investigation as such, but do exercise their adversarial or supervisory authority to guide the police investigation in such ways as advising or instructing the police to carry out their investigation to certain direction. So there are some different roles to play from the perspective of the prosecutor. I, in my civil law tradition, am completely responsible for the acts of the police. You must understand that system. The police cannot start an investigation without the permission of the public prosecutor, and not, specifically not in this kind of matters we are talking today about these ICSANT situations. I am responsible for that. It also means that if there is a real infringement of human rights violation, then I must decide whether to go on or to stop the whole investigation. So this is how it works, very roughly said, in my civil law tradition. Now, Martin was already referring to jurisdiction. In some countries this is mandatory. In my country, I have the possibility to decide not to prosecute. If I think, considering the file, that there is not enough evidence and there is not a perspective for a successful prosecution, I can say I'm not going to prosecute. In my jurisdiction, that's not the end of the case. If you are the victim and you have put forward a complaint to the police, and the prosecutor decided not to prosecute, you can always appeal that and go to the Court of Appeal, and then there will be a new round of arguments in front of the Court of Appeal, and after deliberation, the Court of Appeal can at the end force the prosecution to prosecute. Now, you also have other countries, and that is also one you have to take into consideration if you have to deal with ICSANT matters, and there is another country at stake. Please try to understand the different systems, also when it comes to these legal issues. Let's move on to the next slide. Now, as I said, I am working in a civil law tradition. We have no secret evidence. We have professional judges. We have no jury. And as a public prosecutor, I am fully responsible for the criminal investigation. I can do a lot of things, but for certain coercive measures, I need the permission from the investigating judge. The investigating judge in the civil law tradition, and more specific in the tradition I'm working in here in the Netherlands, is that the pre-detention judge, the investigating judge, is about the pre-detention, but also about permission given or refused when it comes to coercive measures. And because we have a full disclosure in the Netherlands, it means that if I want to use a wiretap in an ICSANT matter, I have to go with a report from the police to the investigating judge. I have to present the facts, the relevant facts, and ask permission for a wiretap. And the investigating judge can refuse that, can limit that, or can also grant that. This whole proceeding, so the request and the decision, must be in the file, so at the end the accused can check whether it is done according to the law. So this is how it works. And last but not least, the investigating judge will not be a member of the bench who is at the end deciding of this ICSANT matter. Now, we are talking about ICSANT. We are talking about a certain material. What is it? What can be used in court? What is allowed evidence in the different courts? Now, I think in most of the jurisdictions, it is the same like us here in the Netherlands. As you can see here on the slide, it is the own observations of the court, but actually the statement of an expert witness might be the most important thing to decide whether it comes to an ICSANT crime or incident. And of course, this is also always balanced with the human rights at stake. Now, where does the evidence come from? I mean, when it comes from counterterrorism, in counterterrorism cases, it can come from the local police, it can come from civilians, from family, you know, the church, the mosque, from everywhere, but it could also come from abroad. And that's interesting for you, for the audience as well, to understand that. Because if you go to the next slide, you see the different actors who can provide evidence to you in your jurisdiction in this kind of cases. So let's go to the next slide, please. So this evidence can come from a state authority. It can come from NGOs, but it could also can come from the military. Also could be battlefield evidence, national, international level. And you could get some information, could also be turned into evidence from specialized organizations like the IAEA, Interpol, Europol. And you might also be interesting to understand that Eurojust, where the magistrates from all these states of the European Union are working together, could also be helping in this regard. And I will come more in detail back to this issue when we are talking about the next webinar about the international cooperation. But it is important for now to understand that Eurojust is there, and you have all kinds of options to get your evidence in terms of intelligence or whatever, can come from different actors. Okay, let's move on to the next slide. And because of these specific elements of these crimes, you need also special investigative techniques. And I already mentioned when I was referring to the slide of the mafia, the Japanese mafia, trying to obtain radiological material, nuclear material, that there was an undercover operation. We need all these special investigative techniques to detect the crimes and investigate it. Let's move on. So let me go through some of these possibilities. We are talking about cross-border surveillance, hearing by video conference, including hearing witnesses by video conference. Can you trust that? And how can you be sure that if you are having this video conference in a way to hear a witness, that it is done in a proper way, if you cannot see the whole room? All these things you have to be aware of. Interception of telecommunications is always very important, and more specifically in my country, where we use that a lot, and it could also be used as evidence. The secret search of a computer system. Also the use of drones would be interesting to consider when it comes to surveillance. In other words, there are a lot of specific techniques more related to these complicated crimes and incidents related to ICSANT. But if you are conducting an investigation, always keep in mind, and I'm addressing now specifically to the judges in the audience and the prosecutors, please don't forget the rights of the defense to challenge the methods and the results of this whole investigation. There must be a moment during the trial that they can challenge the way you have conducted the investigation. Okay, let's move on. And that brings me to the scope of ICSANT. Where are we talking about? Martin was already mentioning that it is limited to offenses that have transnational elements. In other words, the convention is not applicable, with some limited exceptions, if all the following four circumstances are met. And then I'm talking about the offense must be committed within a single state. The alleged offender and the victims are national or state. The alleged offender is found in the territory of that state, and no other state has ground to exercise jurisdiction. When these four circumstances are met, ICSANT is not applicable. So we are talking by definition of an international situation. Okay, let's move on. This is the list of abbreviation I will use in my coming slides. It is important for you to understand when ICSANT is at stake, that there must be at stake that it is unlawful, intentional, and there must be a specific intent. Please remember this: unlawful, intentional, specific intent. Okay, let's move on to the next slide, please. And that brings me to Article 2. There are a lot of articles, very interesting in ICSANT, but I would like to ask your attention more specific to Article 2, because that's, from my perspective, from the perspective of the prosecutor, and also from the investigator, the most important article in ICSANT, because it is about possessing radioactive material. And there you see again, with the intent to cause, etc. But it's also about making a device, also with the intent. But it goes much further than that. It's also about using in any way radioactive material with the intent to cause any, etc. And it's more than that. If you go to the next slide, you see it has a broad range. So it's about demanding radioactive material by threat. It is threatening to commit an offense under Article 2. But it's also about attempting to commit. It's also about organizing or directing others to commit. And contributing in another way to the commission of Article 2 by a group or persons acting with a common purpose. So the intentional contribution, either in order to further the crime or being aware of the group intention to commit it. The intention you have to prove. So keep that in mind if you conduct an investigation when this kind of ICSANT situations are at stake. Keep that in mind that you have to prove the intent. But of course, we are talking about the forensic science. What is forensic science then? I mean, we are, or at least I am, just a simple prosecutor. I am not trained specifically how to qualify forensic results, how to deal with forensics. But forensic science, that can be defined, as you can see here on the slide, as science that assists the criminal justice system. And that's exactly what it is here in ICSANT. In an ICSANT situation, it is assisting you as prosecutor, as a judge, as a lawyer, as an investigator, to understand what's going on, to understand the content of the crime. And it is doing so by providing the framework of criminalistic reasoning, but also critical thinking that form the basis for the selection and also the collection, the analysis, and the interpretation of the traces used in criminal investigations. So this is really important to understand. And that brings me to the next slide. So actually, if you are dealing with an ICSANT situation, let's assume a dirty bomb situation, and you are conducting your investigation, you talk about different situations. You're talking about a report of the crime scene. What happened at the crime scene? What is available, still available? Did you make a video of it? Where their drone footage is? I don't know. And then to analyze what's happening. And then the interpretation. And last but not least, there must be a report for the prosecution, for the investigator, and probably also for the lawyer. Because the lawyer can also ask the contra expertise to come up with another report. At the end, it will end up in court. And you, as a prosecutor, as a judge, as an investigator, have to understand the content of this report, because that's the basis of the crime. Yes, let's continue. But that's not easy. I mean, I don't know how many prosecutors are watching right now, but you will definitely recognize the situation that sometimes when you are in court, for instance, with a doctor, and you are asking him questions, in a lot of situations, the doctors getting annoyed by the silly questions asked by the prosecutor, the judges, and the lawyers, because they don't understand the content. And because the annoyment of the doctors, it creates an annoyment on the other side as well. So we, as simple prosecutors, and as judges and lawyers could also be annoyed by the attitude of the experts, because sometimes we seem to come from a different universe. We don't speak automatically the same language. So it is my advice from the very beginning, when you start an investigation related to ICSANT or to another CBRN crime, to find out whether your expert is really understanding you, the relevant legal questions he has to address, and you are understanding the expert on the other hand as well, that there will be no miscommunication. Because if you are not fully aware as prosecutor what the content of the report of the forensic expert is, you cannot explain it in court. And the same goes for the judges as well. You must be aware what the expert is writing, what the findings are. And the expert must understand that he or she has to write his report in understandable language for everyone. Okay, let's move on to the next slide. So why should you join ICSANT? You know, I'm convinced that ICSANT is providing a lot of benefits for all the people who are dealing with ICSANT situations, possible ICSANT situations. It strengthens the national, the regional, and also the global security. It reduces the risk of impunity of the offenders if you know more about ICSANT. It offers you a common baseline of minimum standards for the legal frameworks against nuclear terrorism. And again, don't think that it is only fictional. It is also possible that it really occurs in your country, in my country, or in other countries as well. And then you have to deal with it. It offers you also a framework for international cooperation in these criminal matters, no matter whether you already have some treaties in place. It offers you a lot of instruments. And being a party to ICSANT contributes to the state's compliance with a lot of Security Council resolutions, as mentioned here on the slides as well. But understand that it is ICSANT, not only ICSANT. ICSANT is complementary to already existing other legal instruments against nuclear terrorism in your jurisdiction, including conventions. So there are a lot of benefits to join ICSANT in the first place and to make use of the tools and the provisions of ICSANT to solve and to prevent very dangerous situations. Okay, let's move on to the next slide. But I'm fully aware as a busy prosecutor that I have so many cases and there are so many things to be done that also my boss is expecting from me that I'm also doing the other cases. So this is where the prosecutor must convince, first of all, his team leader or her team leader, that we are talking about really serious crimes. And probably your bosses will be convinced in the first place that it is a serious crime. You have to convince him or her during the whole process. And I mean during the whole process, it means not only in the first instance, because most of the cases will end in the Supreme Court. So also before that in the appeal court, you must convince your boss that it is worthwhile to get your time to conduct this investigation or to supervise this investigation, because you are really doing a very important job in this regard. So prosecutors must be aware that it is not in their ordinary curriculum vitae being trained in matters like ICSANT, but they have to. Let's go to the next slide. Because training is needed. And there is also some good news for you, because there is a new prosecutor's guide to radiological and nuclear crimes on the horizon, and it is coming soon. And that means that I am convinced, and I would really want to emphasize, that you can do these cases only when you are specialized where you are committed and you have been trained on the content, that you have been aware about the provisions of ICSANT, and that you fully understand the people you are working with, because we are talking about the most serious crime you can imagine. And with this said, I come to the end of my presentation. I hope it was worthwhile for you to listen to. Thank you very much, and if you have any questions left, I would be happy to answer them. Thank you very much.
Thank you, Simon. That was very informative, very interesting. Always a pleasure to hear someone as practiced as you give their insights into specific topics within CBRN prosecution. So thank you for that. I do have a few questions here. So I'll start off with that. You talked about the need for the prosecutor to interact with a number of different stakeholders. You touched on some issues related to evidence gathering, nuclear forensics, and crime scene management. So generally, what other stakeholders does a prosecutor interact with under ICSANT to hold perpetrators of radiological and nuclear crimes accountable?
Yeah, that's a very good question. Thank you very much, Martin. Let me start by saying that first of all, you have to work together with the investigators or the police, because they are in most jurisdictions conducting the investigation. Depends on what kind of system is at stake. But there is this close cooperation between those two. And then, of course, you need some information. So an information officer is also very important. Where does the information come from? And it could be from the secret services. It could be from the police. It could be anonymous. You know, you have to deal with this information flow to use in this very complicated cases. And then last, but certainly not least, you have to deal with competent experts. An expert who is not only an expert on the content, but also an expert in understanding languages. As I try to explain, that if he or she is speaking the same language as you and as the judge, that's fine, that's perfect. But often, at least in my experience, you have a very good expert, but who is not able to explain it in simple words, what happened, because not only the judge wants to know and the accused wants to know, but also the audience wants to know who is following these cases. So there are a lot of actors at stake. And sometimes when it comes to ICSANT, also your counterparts in the other countries are very important. So building up a relationship with other prosecutors, dealing with counterterrorism or war crimes, it could also be an international crime, that's very important.
Just to follow up to that question as well, Simon, those stakeholders, do you primarily just have one counterpart on the exchange of information and evidence as it relates to another country, or are you dealing specifically with experts in those countries as well, or is everything channeled through your counterpart within the corresponding prosecutor's office?
Now, when it comes to a foreign expert, if you mean that, I have to rely on what my colleagues in the other countries are considering a real expert. Let me give you an example. In counterterrorism cases, I see a lot of so-called experts on television explaining what's going on. There must be a reason, Martin, why these so-called experts are never used in court, because they are not real experts. So if you rely on your counterpart in other countries, you can rely on the expert as well, because the prosecutor in the other country is also fully aware that this is a person who could really explain situations, who can analyze the content and what we are talking about, what is at stake, and distinguish these people from persons who cannot. It's all about reliability, and you know, when it comes to the Dutch situation, we have a list, a special list, a register of experts that can be used in typical and complicated cases, also in cases like this. But even when an expert is not in this register, he still or she still can be qualified, and then it depends on his CV, his experience. But I would like personally to talk to this person in advance to find out what his expertise is. Has he ever been explaining things in court, things like this, all these basic questions.
Thank you. I have another question for you here. In your opinion, Simon, what is the most useful tool within the ICSANT toolkit for successfully prosecuting radiological and nuclear crimes?
You know, if you take a closer look at the provisions of ICSANT, and that was also the reason why I focused on Article 2, it gives you a broad scale of instruments to go after perpetrators. And not only perpetrators, also the people who finance these people, who were accomplices. All these people, all these possibilities are covered by Article 2 when it comes to ICSANT. So ICSANT is necessary if you don't have, if you don't have the proper legislation already in place, then ICSANT is absolutely necessary to come up with a successful prosecution in this regard.
Yeah, I'm in agreement with you there because of the scope of Article 2 also extends, as you talked about in your presentation, to attempts, so it doesn't require a completed offense, and those various modes of liability really seem like they would give a prosecutor great latitude in finding an applicable offense to charge an alleged offender with. So yeah, that really seems like something that prosecutors can make use of, but you've really hit the nail on the head that you need to have the proper legislation in place to give effect to all those. Otherwise, a prosecutor can't really, you can't charge someone if there's not a law in place to charge them with. So again, to highlight it, at UNODC, we really work to effectively implement ICSANT and those criminalization provisions with member states. So it looks like we're just coming up at about the end of our webinar. We have a couple more questions, but I'm going to have to conclude. We'll attempt to get back to you if you've sent one through. So with that, I'll just make a short closing. I would once again just like to thank you, Simon, for your time today and your informative presentation. Really a pleasure to hear you speak always, but always learning, always fascinating to hear from you. Simon truly highlighted the special role a prosecutor plays under ICSANT and some of the key mechanisms available in prosecuting ICSANT-specific crimes. I'd just like to let you know that Simon will be our next speaker in this series, touching on more specific issues related to extradition and mutual legal assistance, so under the umbrella of international cooperation in the context of ICSANT. That will be held on the 7th of June at the same time, 14 o'clock Central European summertime on Friday, the 7th of June. Invitations will be forthcoming. I'd like to thank you all for taking the time here to join our webinar and sending your questions in. And lastly, I would like to thank the European Union, for which this webinar would not be possible without its financial support to UNODC and for its further contributions to the promotion of the convention. With that, I'll end the event and thank everyone for your time and wish you a pleasant weekend. Thank you. And thank you, Simon, again.
Thank you, Martin. Thank you all.
Bye, everyone.